Breaking news in the Jeffrey Epstein controversy. A federal judge has just rejected the Trump administration's request to make grand jury documents in the case public. The judge had this to say in his ruling, quote, "The information contained in the Epstein grand jury transcripts pales in comparison to the Epstein investigation information and materials in the hand of the Department of Justice." We have CNN legal analyst Elliot Williams with us now. Quite a response from the judge there, Elliot.
It is quite a response, and he even uses the language I thought you were going to quote, Brianna, is where he says that the Justice Department has a substantial investigative trove in their possession.
The courtroom falls into a heavy, suffocating silence. Trump's attorneys lean in close, their faces drained of color as the judge lifts a stack of sealed files, the red evidence ribbon trembling between his fingers. Trump's jaw locks in place, his hand gripping the edge of the table as if bracing for impact. The judge's voice slices through the room. These documents should have remained sealed only if they posed a clear threat, but the public's right to know is greater. A whisper from Trump's lawyer follows immediately, tight and urgent. If he unseals all of it, you could face criminal exposure. Not civil, criminal, perjury, criminal contempt, false statements. The risks suddenly feel painfully real. Legal analyst Elliot Williams studies the ruling from the gallery, his eyes widening when he reaches a particular line. The information in these transcripts pales in comparison to what DOJ already holds. A ripple moves through the room. If this is the less damaging material, what exactly does the Department of Justice possess? A clerk steps forward with a thick binder labeled Grand Jury, Epstein. The room freezes. Trump remains perfectly still. One of his lawyers is shaking so badly that a pen slips from his hand and rolls across the floor. The judge begins to read. Each word feels heavier than the last, dragging the moment deeper into uncertainty. Civil penalties seem almost irrelevant now. This is the territory of criminal consequences, and everyone senses the shift. Trump stiffens as the judge reaches the final seal. Once this is opened, everything changes. The judge breaks it.
The Justice Department has now released a big new batch of documents in the Jeffrey Epstein investigation, and these include new details about Epstein's one-time friendship with President Trump. Look, there is a lot to go through. We said it's like more than 10,000 pages, so we are digging through this, but this is what is seen so far. In a 2020 email, an assistant U.S. attorney for the Southern District of New York wrote that Trump traveled on Epstein's private jet, quote, more times than previously has been reported.
The room was so quiet that even the soft shuffle of papers sounded loud. Every seat inside the federal courtroom was filled, every journalist on edge, and every pair of eyes fixed on a single man. The federal judge preparing to unseal a set of long-anticipated documents linked to one of the most politically heated investigations of the past decade. Subscribe to Reports on States, because today's story isn't just news, it's history unfolding in real time. As the judge lifted the sealed folder, the tension immediately spiked. Trump's legal team leaned forward, whispering rapidly to each other, their faces strained. This was the moment their strategy had hoped to delay. For weeks, legal analysts had speculated about whether the court would authorize public access to these confidential records. And now, after months of motions, objections, and hearings, the judge made his decision clear without saying a word. The seal was coming off. Observers noticed Trump's expression shift. His jaw tightened. His posture went rigid. Cameras weren't allowed inside, but those present described the atmosphere as electric, dangerous, even volatile. Because everyone understood what unsealed documents represent in Washington, not just transparency, but political shockwaves. The judge began reading portions of his order. His tone was steady, but the words carried enormous weight. He explained that the public interest in understanding the material outweighed arguments for continued secrecy. It was a legal principle rooted in Supreme Court precedent. When public accountability intersects with evidence of significant national concern, transparency becomes a constitutional priority. But the judge also emphasized something else, something far more unsettling. He said the contents of these unsealed documents should be evaluated carefully by the Department of Justice and Congress, as they raise questions exceeding the scope of the initial case. That sentence alone sent a ripple through the room. Legal scholars later compared it to the moment Judge John Sirica first hinted, subtly but unmistakably, that the Watergate tapes might contain more than the public realized. When a federal judge signals, "There's more here," Washington listens. As the clerk handed copies of the order to attorneys, one of Trump's lawyers appeared visibly rattled. Their hands trembled slightly as they flipped through the pages, their eyes darting rapidly across the lines. Another attorney muttered something barely audible, something about possible exposure, according to someone who overheard it. Court observers said Trump didn't move. Not a blink, not a twitch, just a frozen stare fixed on the bench. It was as if he were bracing for an impact no one could fully predict. Political strategists outside the courthouse immediately began analyzing what this could mean. A routine release? A procedural update? Or the beginning of a much larger political and legal battle? Because inside those documents, according to earlier filings, redacted memos, and legal motions, were references to financial reviews, internal communications, investigative summaries, and testimony excerpts that had long been the subject of speculation. Nothing confirmed, nothing proven, but enough hints over the years to fuel questions that had never received clear answers. Now, for the first time, a judge was signaling that some of those questions might finally get them. The courtroom waited as the judge reached for the final envelope, the one containing the summary index of what would be released to the public. He broke the seal. A whispered gasp spread through the gallery, and as Trump's eyes locked onto the pages, the room felt like it shifted. The story was no longer about what might be inside. It was about what happens now that the world would see it. The sealed pages now lay open, and the gravity of what had just happened began to sink in. Reporters and staff quietly shuffled through the courthouse, murmuring about the possible contents. While the public wouldn't see the documents immediately, the very act of unsealing had already shifted the political landscape. Legal analysts on live television began dissecting what this could mean for the administration, carefully choosing words like questions raised, potential scrutiny, and ongoing investigation, emphasizing that the contents were not proven evidence, but the documents themselves were official and verified by the court. Inside the Oval Office, Trump's team scrambled to coordinate a response. Counselors whispered urgently, flipping through summaries and memos. Every line of the documents had the potential to become a headline by morning. Staffers reported that even briefings that were intended to be routine quickly turned tense as aides tried to anticipate which parts of the material would attract the most public attention. One source described the mood as defensive, almost panicked, with legal advisors debating the fine line between transparency and obstruction. Outside the immediate political circle, Congress began mobilizing. Lawmakers on both sides were reviewing the court's order, analyzing the implications. Legal scholars noted that while unsealing documents does not equate to criminal liability, it often triggers investigations or opens channels for further scrutiny. The public release of even partially redacted information could shape narratives, influence hearings, and affect political alliances. Analysts repeatedly stressed that the timing of such unsealing can be as important as the content itself, particularly in a highly charged political environment. Meanwhile, the media coverage intensified. Every broadcast, tweet, and article dissected the implications, emphasizing procedural elements and legal context. Experts highlighted distinctions. A document being unsealed doesn't prove guilt. It simply allows investigators, journalists, and lawmakers to access material previously restricted. Legal commentators repeatedly explained civil versus criminal distinctions, emphasizing that unsealed evidence may trigger subpoenas, interrogatories, or congressional inquiries, all of which carry serious consequences for anyone under review. Inside the administration, advisors were weighing options. Press statements needed to walk a careful line, assert innocence, highlight procedural compliance, and avoid suggesting that attempts to limit access were improper. Yet the sheer visibility of the unsealing, combined with the immediate, visceral reaction observed in live footage, created a psychological pressure no team can fully control. Observers noted that human responses to such high-stakes revelations can sometimes speak louder than words. Analysts called it a moment frozen in political time, where nonverbal reactions are scrutinized for meaning. The documents reportedly included financial summaries, travel records, and internal correspondence dating back decades. Experts on financial compliance and investigative law emphasize that even indirect references could be legally significant, triggering follow-up investigations, requests for verification, and potential subpoenas. These procedural nuances, while technical, carry enormous real-world implications. Missteps or misstatements could result in civil or even criminal inquiries, depending on what investigators determine. As the day wore on, the political tension grew more intense. Opposing party leaders began preparing statements, emphasizing accountability and transparency, while allies quietly assessed risks. Newsrooms simulated every possible headline, carefully weighing language to maintain accuracy while capturing audience attention. Inside political and legal circles, whispers of next steps and implications dominated conversations. Observers noted that in situations like this, the ripple effect of unsealed documents can extend far beyond the immediate legal environment, shaping public perception, influencing midterm elections, and redefining alliances within the party. In short, the release of these files set in motion a cascade of strategic, legal, and political reactions. Everyone understood the stakes. Each document could be dissected, debated, and used to influence policy, perception, and legal outcomes. The countdown, though unofficial, had begun. By the evening, the political atmosphere had shifted into high alert. Capitol Hill was buzzing with aides and staffers, each tracking updates from court filings, press briefings, and media leaks. Lawmakers scrolled through early reports, trying to parse the potential significance of the unsealed materials. Even without seeing every document firsthand, analysts emphasized that the unsealing itself sent a strong message. The court considered public access to this information to be in the national interest. That procedural detail alone was enough to put pressure on both parties to respond strategically. Inside the White House, the pressure was immediate and palpable. Counselors gathered in small huddles, whispering updates and potential responses. Legal advisors discussed the consequences of missteps, emphasizing that any public misstatement about the contents could trigger civil or criminal scrutiny. Even the tone of a statement matters, one source later told journalists. It can be considered evidence of intent or consciousness of the issue. Every word, every reaction, was under scrutiny, and no one could afford a lapse. Meanwhile, media outlets began providing detailed breakdowns of the process. Experts explained that while unsealed documents do not automatically prove wrongdoing, they allow investigators and lawmakers to request clarifications, issue subpoenas, or conduct hearings. The distinction between civil and criminal implications was highlighted. Civil consequences could include fines, regulatory action, or disclosure obligations, whereas criminal consequences could involve perjury, obstruction, or contempt, all serious matters with potential jail time. Public understanding of these nuances became crucial as speculation and commentary swirled across news cycles and social media platforms. Analysts also began contextualizing the unsealing within a broader political and legal framework. Similar historical precedents were cited: Watergate, Whitewater, and other high-profile federal inquiries where document disclosure became a tipping point. Legal experts emphasized that unsealing does not equate to conviction, but it dramatically increases public and congressional awareness, which can accelerate political consequences. In Washington, perception is often as powerful as fact, and officials were acutely aware that optics could influence decision-making on both sides of the aisle. As the hours passed, lawmakers reportedly began discussing potential next steps. For some, the court's decision provided justification to accelerate investigative efforts or prepare oversight hearings. Staffers highlighted the importance of timing. Any delay could be politically costly, while rushing without preparation could create procedural vulnerabilities. The balancing act between legal prudence and political strategy was delicate, and every move carried risk. Sources indicated that behind closed doors, discussions focused on evaluating which lines in the unsealed documents could form the basis of inquiries and what procedural mechanisms would be necessary to pursue them. The public, meanwhile, reacted to the story with growing intensity. Social media amplified clips of the live response, legal analyses, and speculation. News networks highlighted the importance of transparency, the procedural significance of unsealing, and the potential implications for governance. Commentators frequently reminded audiences that while the documents themselves might contain redactions, the act of unsealing conveys legitimacy, signaling that prior attempts to maintain secrecy were being challenged by judicial review. That procedural framing helped the public understand that the situation was not simply political theater, but a legally recognized process with real-world consequences. Inside legal teams, strategic calculations intensified. Attorneys evaluated risks of voluntary disclosure versus reactive defense, debated framing statements carefully, and assessed potential congressional requests. Advisors noted that in high-stakes cases, internal coherence of messaging is crucial. Any inconsistency could be interpreted as awareness of sensitive content or obstruction. The sense of urgency was amplified by the public attention and the potential for rapid dissemination of information. As hours became days, every person involved understood that the unfolding events could redefine political alignments and legal strategies. The following morning, the story exploded across every major news outlet. Headlines framed the unsealing as a pivotal moment in ongoing investigations, emphasizing the legal and political weight of the documents. Analysts repeatedly explained the practical consequences of such releases. While unsealed documents do not imply guilt, they enable investigators, Congress, and regulators to follow leads, request clarifications, and evaluate patterns of activity. Even subtle details in redacted materials could become central to oversight inquiries, financial audits, or legislative hearings. Inside the administration, advisors worked tirelessly to anticipate which portions of the documents could spark public scrutiny. Every internal memo, financial summary, and email excerpt had the potential to be analyzed by reporters or lawmakers. Counselors debated messaging strategies, weighing statements that could reassure the public versus statements that might inadvertently acknowledge sensitive points. Legal advisors emphasized procedural accuracy. Any misrepresentation could trigger subpoenas or claims of obstruction. The pressure of managing perception while navigating real legal risk created a palpable tension inside the offices. Meanwhile, congressional staffers began preparing for hearings. Committees responsible for oversight, ethics, and finance were reviewing the judge's order, analyzing which portions of the unsealed material could justify further action. Lawmakers debated procedural rules, including how to issue requests for testimony, verify evidence, and ensure that their inquiries remained within legal bounds. Analysts emphasized the importance of following civil versus criminal distinctions. Civil actions could involve disclosure obligations or regulatory review, whereas criminal implications, if any, required careful investigation by authorized bodies. The complexity of these procedural safeguards was critical, given the high stakes. Media coverage amplified the stakes further. Live coverage described the tense reactions inside the administration, the legal community, and Congress. Experts repeatedly stressed that the unsealed documents were verified by the court, giving them official weight without implying guilt. Commentators explained that the mere act of unsealing signals judicial confidence in the public interest of disclosure, creating a situation where all involved, political allies, advisors, and legal teams, must operate under intense scrutiny. Every statement, reaction, and briefing was now part of the public record, potentially influencing future hearings, investigative actions, or political narratives. Across the political spectrum, reactions varied, but the consensus was clear. The unsealing was a catalyst for immediate attention. Opposition leaders framed it as an opportunity for oversight and accountability. Allies emphasized due process, cautioning against jumping to conclusions. Both sides recognized that the unfolding events were being observed in real time by millions of citizens, making every move consequential. Analysts highlighted the psychological and strategic pressure this creates. When officials know that public and legal scrutiny are simultaneous, decision-making becomes more deliberate but also more constrained. Inside legal teams, advisors evaluated risk contingencies. Scenarios were mapped for potential public disclosure, congressional inquiries, and media narratives. Every word in official statements was reviewed, every internal communication scrutinized for consistency. Observers noted that even a single slip could become a headline or be interpreted as evidence of awareness or intent. The balance between transparency and self-protection was delicate, and counsel worked to maintain both. By midday, the situation had crystallized into a high-stakes political theater. The unsealed documents were no longer hypothetical. They had real-world procedural, legal, and political implications. Investigators and lawmakers began aligning strategies. Communications teams coordinated messaging, and analysts continued to interpret every move. Public perception was shifting, and insiders understood that each decision, every word, pause, or statement could affect not only the immediate narrative but the long-term political and legal outcomes. The tension was palpable. The next steps would define not just the immediate response, but the broader trajectory of accountability, oversight, and public trust. And everyone watching knew nothing would move slowly from here. By the afternoon, the unsealed documents had triggered a chain reaction across multiple fronts. Congressional committees were now actively reviewing summaries, redacted excerpts, and procedural filings. Staffers analyzed the potential scope of follow-up actions, including subpoenas, depositions, and requests for further documentation. Legal experts emphasize that while unsealed materials do not constitute charges, they create pathways for oversight that can lead to significant legal and political consequences. Inside the administration, the pressure intensified. Advisors debated whether to proactively release clarifications or remain silent, while legal teams reviewed the documents in detail. Every statement carried risk. Misrepresenting content could trigger accusations of obstruction or misleading officials, while withholding information could be framed as evasive. Sources described the situation as a tightrope walk, with the administration's credibility hanging on each word, pause, and briefing. Staffers worked around the clock, coordinating internal communications, messaging, and legal strategy, fully aware that the public and media scrutiny was relentless. Meanwhile, newsrooms dissected the procedural nuances of the unsealed material. Analysts repeatedly explained distinctions between civil and criminal implications, outlining how investigators might pursue leads or request clarifications. Commentary emphasized that unsealing signals judicial confidence in the public interest of disclosure, and that the mere existence of official documentation can prompt congressional inquiries, regulatory review, or even litigation. Experts noted that such procedural authority carries weight independent of content, creating ripple effects across political, legal, and financial arenas. Observers in Congress began weighing their next moves. Oversight committees and ethics offices evaluated the legal frameworks for potential actions, reviewing rules regarding documentation, subpoenas, and witness testimony. Analysts noted that even redacted or partially disclosed records can be pivotal, providing enough detail to justify hearings, verification requests, or investigatory steps. Behind closed doors, legislators debated timing, procedural formalities, and political optics, all while monitoring media coverage and public sentiment. Every decision had immediate and long-term consequences for reputations, careers, and public trust. The media coverage continued to amplify the stakes. Live broadcast highlighted both procedural explanations and political analysis, emphasizing that the unsealing created legal access without implying guilt. Experts stressed that these were verified, court-authorized documents, meaning they could serve as a credible basis for follow-up inquiries. Analysts also explained the significance of timing. The rapid release and immediate public attention created a pressure cooker environment for decision-makers, advisors, and officials. Every misstep could be amplified, every hesitation interpreted, and every misstatement recorded. The psychological impact inside the administration was also apparent. Sources described tense discussions, hand gestures, and unspoken anxiety as advisors assessed the unfolding implications. Legal teams mapped scenarios based on different reactions from lawmakers, media narratives, and public perception. Each potential step, whether voluntary disclosure, congressional testimony, or public statements, carried legal and political risks. Observers noted that such high-pressure environments often reveal internal divisions, as advisors prioritize different approaches to managing scrutiny and minimizing exposure. As evening approached, it became clear that the unsealed documents were more than just a procedural development. They had become a catalyst for political and legal momentum. Media analysis framed the release as a turning point. Congressional staffers prepared to act, and administration teams struggled to contain both perception and potential consequences. The procedural release had set the stage for immediate follow-up actions, and all stakeholders understood that the coming hours and days would be decisive. The countdown, unspoken but universally felt, was well underway. As the evening deepened, the tension inside and outside the administration reached a fever pitch. Congress had begun coordinating responses, reviewing the court's unsealing order line by line, and preparing procedural motions for potential hearings. Staffers meticulously cross-referenced dates, financial records, and travel logs to identify areas requiring clarification. Analysts explained that such preparations are standard in high-stakes oversight cases, emphasizing that the goal is transparency and accountability rather than immediate judgment. Inside the administration, the focus shifted to strategic communications. Legal teams advised caution in all public statements, noting that mischaracterizing the documents could result in civil or criminal exposure. Advisors debated how to frame responses while balancing the public's demand for clarity with legal prudence. Every briefing, press statement, and internal memo was scrutinized for tone, wording, and implication. Staffers described the atmosphere as intense, almost suffocating, with every action and reaction under the microscope. Media coverage continued to dissect procedural and political ramifications. Experts highlighted the importance of the distinction between unsealed documents and confirmed wrongdoing, repeatedly explaining civil versus criminal consequences, the potential for subpoenas, and the role of Congress in oversight. Live analysis underscored that unsealed files, while not proof of guilt, empower investigators and legislators to ask pointed questions, verify details, and potentially escalate inquiries into formal proceedings. Every detail, from financial summaries to travel logs, became a focal point for discussion, speculation, and public interest. Political leaders began weighing their options. Allies emphasized due process and cautioned against assumptions, while opposition lawmakers signaled readiness to leverage the documents for oversight and accountability. Analysts noted that public perception now carried equal weight to procedural steps. Optics, reactions, and communication strategy would influence both immediate responses and longer-term political consequences. Every statement, video clip, and news report contributed to shaping the narrative, creating an environment where precision and timing were critical. Inside legal and political teams, contingency plans were mapped meticulously. Scenarios ranged from voluntary briefings to congressional testimonies, each carrying distinct procedural, legal, and political risks. Advisors emphasized that accuracy and consistency were paramount. Even minor errors could be amplified in media coverage or misconstrued as obstruction. Observers noted that in situations like this, the convergence of legal scrutiny, public attention, and political consequences can accelerate decision-making, leaving little room for hesitation or error. By nightfall, the unsealed documents had solidified their impact. They were no longer just papers or digital files. They had become a defining element of the ongoing political and legal narrative. Analysts described the situation as a turning point, a moment where procedural transparency, public attention, and political strategy intersected. Lawmakers, media, and advisors recognized that every subsequent step, hearings, statements, or inquiries, would be shaped by the unsealed material and the reactions it elicited. The day closed with a sense of historical weight. The unsealed documents had triggered procedural reviews, political debates, and legal scrutiny, setting in motion a sequence of actions that could have long-term consequences for governance, oversight, and accountability. Inside and outside the administration, everyone understood the stakes were high and that the coming days would be critical. The story was far from over, but the release had fundamentally altered the political and legal landscape, and the public was watching every move with unprecedented attention. Thanks for watching, and make sure you're subscribed to Reports on States.